Thank you for joining us on Coffee Break, brought to you by the Middle Alabama Area Agency on Aging, or M4A. M4A is a part of a network of 13 area agencies on aging that cover all 67 counties across the state. We are located in Alabaster, and we cover Blount, Chilton, Shelby, St. Clair, and Walker counties. We would love to find out how we can help your family today. For previous episodes of Coffee Break, feel free to check out our YouTube channel. All right, we're going to go ahead and kick things off. If you join us late, we will be recording this, so feel free to wrap back around and watch it either on the Facebook Live video, or we will be reposting this on our YouTube channel probably as late as Monday of next week. So just be on the lookout for that. Jennifer, do you guys still see my screen?
Yes, we do.
Okay. All right. So welcome everybody to Coffee Break Session 12. For those of you that have not joined us before, we welcome you. This is an initiative that the Alabama Cares and our Panda Project, as well as some of our other staff members, have kind of put together a series going back to really when COVID first got started. So we've been doing these every other week, and we're now up to session 12. So we're excited to continue this series, and we're glad that you joined us today. Coffee Break is brought to you by two of our in-house programs, which is our Panda Project, which is providing Alzheimer's and dementia assistance primarily in the Shelby County region of Alabama, and our Alabama Cares program, which is a support for caregivers program that covers all 5 of the counties, which we will go over towards the end of this session. Today's guest speaker is Ms. Jan Neal with the Jan Neal Law Firm out of Opelika. Jan is a great partner of M4A's for all of our programs and has been for years. She's an expert in elder law, and we are very thankful that she took the time to join us today to answer questions that you all may have, as well as questions that you don't know that you will have after you get done hearing her presentation. So without further to say, Jan, I'm going to pass it on to you. I'm going to stop sharing my screen and let you pull up your screen. So welcome again, and thank you for joining us.
Hi, everybody. It's really good to be here. We're going to talk about legal issues for caregivers today. I'm going to offer you a good bit of information and some resources where you can get more information about the different topics that we talk about today. I want to encourage you to ask questions. We'll either answer the questions in this forum, or if there's anything that you feel like wasn't answered, I want you to feel free to get in touch with me. And this is my contact information. These slides will be made available right after this presentation. You'll be able to get them at SlideShare, and they'll be posted onto my Facebook page, Jan Neal Law LLC, and I believe Panda will also list the slides there. But anyway, you can reach me, and I'll be happy. I don't want anybody to be left with questions unanswered. One of the things about being a caregiver I have found is that so often people get thrust into that role and they didn't intend to. I like to say that dementia is not a polite disease. It's something that just happens. And a lot of times people are just not prepared for it. I do think that when you look at the critical issues that caregivers need to understand, it's important to understand that there are numerous things that all of a sudden you need to know, and you need to know it all at once. And so that's why any one of these topics that we're talking about today could be the entire hour-long presentation. But we're going to hit the big points, and I'm going to provide you with information on how to get more information on these different issues from other places. I do want to reemphasize that my firm provides no-cost Older Americans Act legal assistance for people who are 60 and over in the Middle Alabama Area Agency on Aging region, and that's covering Blount, Chilton, St. Clair, Shelby, and Walker counties. You can contact me directly at the contact information provided in these slides, or you can contact M4A and they'll refer you to my office. Spotting dementia is really important. Tragically, it does seem as though dementia comes to the surface when bills aren't paid, I can't tell you how many times I've seen in guardianship proceedings that the utilities were cut off or insurance lapses because people didn't pay their premiums. And worst is when a scam happens and all of a sudden it's uncovered that someone was not using their best judgment. And not only have they lost their property, a lot of times they lose their dignity as well. But with that said, you'll understand why I recommend that couples pay their bills together or at least put their eyes on finances. I know that it's not at all unusual for, say, a husband to do all of the financial work or the wife may be the one that pays all the bills, but it's really a good idea to have both people keep an eye on everything. And if you're a single person, perhaps give access to your accounts to your attorney, in fact, under a power of attorney, just so long as someone can access information about what's going on with your finances. And the reason I say that is because when you least expect it, you run into a case where a husband and a wife were rocking along and everything looked great, and all of a sudden $40,000 was lost one way or another. Now the wife steps in as a caregiver, but with a lot less finances than she thought she was going to have to deal with those problems. So it really does pay to be very careful about where money's going and how it's being used. Another thing is I've dealt with a number of cases where the children live in another state and they're trying to provide care for their parents in Alabama. And I've seen situations where the kids look the other way because they just don't have time to deal with it. And I would say that it's very important that if you're going to serve as an agent for someone, you need to keep an eye on what's going on, because it's always when people are looking the other way that someone gets in trouble, either with some kind of a contract that they signed up for, some kind of a deal they got into. The problems are just endless that someone can get into if they're not using their best judgment and they're operating with diminished capacity. So if you are the agent, keep your eye on the ball and make sure you know what's going on. We're going to look at the threshold issue of authority to act for another person. This is extremely important because the quality of someone's life can be severely diminished if they do not have good people looking out for their well-being. A lot of times families say, well, that's not going to be a problem. You know, I'm someone's wife, I'm someone's husband. I shouldn't have any trouble handling their business. And that may be true as long as they have a bank account and you're on that bank account and bills can be paid. That's great. All the way until you get to the point where somebody's looking at long-term care. And in those settings, a lot of time, legal capacity is required. And don't think you have legal capacity just because you're married to someone. You don't. One of the worst cases I ever handled was a husband who had to get a guardianship and a conservatorship over his wife. And they were in their 30s because he couldn't create a Medicaid income qualifying trust to qualify his wife for Medicaid. So we had to go get a guardianship and conservatorship, which could have been avoided with a power of attorney. But that's just to give you the extreme set of circumstances that will show you how you've got to have the ability to enter into contracts and to sell property and to set up income trust if the person's income is too high for Medicaid. You have to be able to give liens to Medicaid, access money in bank accounts, and handle all the transactions that are needed to get someone the care that they might need. When an individual can't direct their own medical care, then you've got to have a medical agent to take over and make routine medical decisions. And if a person's terminal or permanently unconscious, a healthcare proxy is needed to direct end-of-life decisions. So think about those three different powers. Do you have someone with the power to handle your finances? Do you have someone with the power to make routine medical decisions for you? Not end of life, but routine. And do you have someone who could make those end of life decisions if you should be terminal or permanently unconscious? And these are generally the powers that you're looking at in making your documents to make sure that they're covered. All legal authority roles have in common that someone is becoming legally empowered to act for another person as their agent or their surrogate. And I do want you to understand that all states have their own agency laws, and they can vary significantly state to state. There are also other ways that you can acquire authority over someone, and we're going to talk about some of those today to try to iron out the differences in those. But do recognize that a power of attorney that's created in another state that was legally created when it was created is supposed to be recognized in Alabama. Now, the problem with that is, how do you know? You know, where do you get a legal opinion on that? Was this South Dakota power of attorney actually legal in South Dakota? This is why I recommend that if you have someone moving into the state, it's best to just, if the person still has the ability, to make a new power of attorney that adheres to Alabama law. Now, the documents that you're looking to prepare for disability and death include a durable power of attorney for financial decision-making, a healthcare directive, and that can be done through a power of attorney. It can be done as a separate healthcare power of attorney or an advance directive for healthcare. End-of-life decisions can be done through a power of attorney or through an advance directive for healthcare. And then other documents that probably should be gotten in order if it's possible, if enough capacity is left, is a last will and testament or a trust or proper beneficiary designations on various accounts. To tell if a power of attorney is durable, and what I mean by durable, I think by now most people understand this, but at common law, powers of attorney were not durable. And that meant that if a person lost capacity, the person that was their agent could no longer act for them. Along came the durable power of attorney that was durable enough to outlast someone's incapacity. And that's all we think of today, right? But that was not originally under the law the way it was designed. But a durable power of attorney remains in full force and effect if a person should lose their capacity. And the way you can tell whether you have a durable power of attorney or not is look at the date that it was signed. If it was on or after January 1st, 2012, an Alabama power of attorney is presumed to be durable. Back before January 1st, 2012, in order to make a power of attorney durable, you had to have specific language in the document that said this power of attorney shall not be affected by disability, incompetency, or incapacity of the principal, or any equivalent language of that nature. All the old powers of attorney are still grandfathered in. And so if somebody has a power of attorney from 2008, you would have to just look and see, does it have that special language? If the power of attorney is January the 15th, 2012, you don't have to look for that special language because they're all presumed to be durable after that date. You can go to our website, which is www.janneallaw.com, and we have an ebook there entitled Guide to Alabama Advance Directives. And there's also another ebook entitled Guide to Planning for Death, and both of these will give you a lot of information on this topic. Now, whenever someone makes a power of attorney, they have to have a pretty high level of capacity. And, you know, in the beginning stages of dementia, when someone is just beginning to realize they have problems, very often people still do definitely have the capacity to make a power of attorney. This is the time to move before any kind of judgment goes down any further. A lot of times we'll have people who will call us and they'll say, my mother's in a nursing home, she's had a stroke, she can't talk, and we need a power of attorney. Well, it's not very often that someone who's in that bad a condition, how can you tell if they understand what it is that you're preparing for them? So it's very important to move before someone has reached a point they can't make these documents. Sometimes when it's questionable, for instance, My husband's had dementia for 4 years, or was diagnosed with Alzheimer's 5 years ago. Well, you know, there's a lot of question in that situation. And this is the form that we provide to the client to provide to their doctor to request a medical opinion concerning capacity. We try to explain that a power of attorney can be a very serious document and it can be used to exploit someone. And so it's important that someone who knows this person and their level of functioning can provide evidence, so to speak, of whether the maker of the document has the ability to receive and evaluate information and to make and communicate decisions demonstrating the ability to manage property or business affairs. This is basically the standard required by law to execute a contract. And so, as you can see, the capacity level has to be fairly high for someone to prepare a power of attorney. If the doctor will provide an opinion to that effect, then we will take it and, based on our opinion and the doctor's, prepare the document, or we might not. It just depends on what our judgment finally is. Now, one thing I do want you to understand is that there is a form durable power of attorney, but I think that it needs a little bit of hammering out and an improvement, let's put it that way. The Uniform Power of Attorney Act doesn't automatically allow an agent to create specific types of trust. Trust in general are addressed, but for instance, a Medicaid income qualifying trust is not mentioned in the form power of attorney, neither is a special needs trust. And this is really important to have those individual types of trust designated in a document, because the bank is looking for that when they open a bank account for the Medicaid income qualifying trust. And the Alabama Family Trust is looking for specific language that will enable the agent to create a special needs trust. And if a special needs trust is needed and the power of attorney doesn't grant that authority, permission must be gained through the probate court. There's this procedure known as a single transaction proceeding. And even though it's not a full guardianship or conservatorship, it still requires a good bit of work just to get the authority to create the trust you need. So I think it's better to have a power of attorney that is prepared with all of these long-term care issues in mind. There's no HIPAA personal representative to access medical records named in the standard form either. So I think that should be also included in any power of attorney that's created. Now, don't worry, we're going to talk in a minute about special needs trust and the Medicaid qualifying income trust. So I don't want to leave you thinking that I'm talking about things that I haven't explained yet. And remember, if you have any questions, you can put them in the sidebar. And Jennifer, I'm assuming you or Jeremy will let me know if anyone has any questions.
That's correct.
Now, let's talk about some practical considerations related to powers of attorney. It's important to name an alternate. A lot of times you'll see that a husband and wife will come in. He'll name her, she'll name him. And then that's cool. But it's also good to say, in the event that if my agent cannot act for me, then I name, and you name someone else, because you don't want the husband to die and the wife to have to run out and create a new power of attorney. The last thing that she needs to do when she's trying to deal with losing a spouse is to create a new power of attorney. So it's a good idea to look at alternate situations that can arise and prepare for them. This is one of the most important things I'm going to say today for a caregiver. So hear me on this one. An agent should always sign as follows: the principal's name by the agent's name as agent or attorney in fact, or a like designation. An example would be John signing a nursing home admission contract for Mary would sign Mary Jones by John Jones as agent or POA, or Mary Jones by John Jones as attorney in fact. The point here is that Mary's signing the contract. Mary's the one who is contracting. It isn't John. And it's important to keep this in mind and to sign correctly, because you don't want John to incur personal liability under that contract. You don't want anybody to have an argument that John signed the contract to be personally liable himself. He signed only as an agent for Mary. Now, generally speaking, a power of attorney does not need to be filed with the court unless there's some kind of a real estate transaction going on, and you've got to have clear chain of title. So if John is signing for Mary on a deed or something of that nature, whenever they check the chain of title, it's a real good idea to have that power of attorney that gave him the authority to sign for her of record at the probate court. But generally speaking, powers of attorney are not filed with the court. Now, I do want you to be aware of other authority granting documents. The living wills do not name an agent. Alabama was one of the first states out there on these authority issues, and introduced into law in 1981 was the living will statute. And all it really did was allow a patient to give the physician instructions about artificial life-sustaining procedures that should be used if the patient should be terminal. Originally, there just wasn't even a document that authorized any, gave the patient the right to give instructions to a doctor about being in a persistent vegetative state. Even though Alabama law did advance over the years and provide agent designation, the old living wills were grandfathered in. And to this day, I'll run into people and say, do you have a power of attorney? And they'll say, oh no, I have a living will, I don't need that. And a lot of times I think people are not aware of just how limiting the living will is. The living will sits in some doctor's file, and that may or may not be the doctor treating you if you end up in an end-of-life situation. It's really not stating anything except asking a doctor not to artificially keep you alive. And that's just incredibly limiting whenever you consider all the other alternatives you have now, like naming agents who can discuss your condition with a doctor and reach a decision and give definitive instructions on what you would have wanted. Now, the Advance Directive for Healthcare was the 1997 amendment to the living will. I call it the new and improved living will. And it indicates the treatment and the food and hydration preferences of the person if he should be terminally or permanently unconscious. You can name an agent as a healthcare proxy, but you don't have to in that document. And you can say that you want your wishes to be honored first, or not at all if the agent has a different opinion, or you can pretty much decide in what order the medical people should listen to you, the document, the agent. And I'm not a big fan of the Advance Directive for Healthcare because I've seen people confused by it. And you have to mark different boxes on there, initial different parts of it. And it just seems to be kind of a blanket instruction when you don't really know if you were to become seriously ill, what are the issues that would have to be considered? It's more than food and hydration. There are a lot of things that come into play in a complicated medical situation. If you do have the Advance Directive for Healthcare, for your healthcare proxy, or the document designating a healthcare proxy, then you would need to have a separate power of attorney to address financial decision making. My preference is to see all of the powers put into one document, which is the durable power of attorney. Now,
Jan,
yes.
I hate to interrupt you, but I wanted to hit you with this question before we moved on. Someone just asked, can they decide on people's treatments?
Yes. Yes. If you name that person to stand in your shoes for routine healthcare decisions or for end-of-life decisions, that person is just like a financial agent, but it's about your health. Would she want to go on dialysis or would she not? Yes, I want her to go on dialysis, but it allows that agent to talk to the medical providers and get all the information to make a decision. Did that answer your question?
Probably so.
Okay.
Yes, it did. She just confirmed it did.
Okay. Now there is another document. I just want you to be aware of it. You could probably go your whole life and never see one of these. I think that in my career, I've seen maybe 2 or 3, and it's called the Certification of Healthcare Decision Surrogate. It's what I call the self-appointed agent. Under Alabama law, you can self-appoint. You can say yourself, I'm going to step out there under the authority of this document and make end-of-life decisions when the patient has not created an advance directive. Under the law, there are specific people who can be named in the line of priority who can serve in the self-appointed position. And that includes a court-appointed guardian, the spouse, adult children, the parent, sibling, other next of kin, or the ethics committee for a facility. Now, isn't that surprising? The ethics committee for a facility can actually make end-of-life decisions for you if you have not made your own advance directive. Now, the person or the committee creating this self-appointing document has to certify some things: that no advance directive exists of which they're aware, contact was made with one or more of the persons who were higher in priority and they consented or expressed no objection, or no contact was made because the person or persons in higher priority couldn't be reached because their whereabouts are unknown, or they're in a remote location and cannot be contacted, or the person in higher priority has been adjudged incompetent. So you do have to have all of these, assurances put into the document. But I do want you to realize that it's not very likely that end-of-life decisions will be made without, once this document's put in place, taking it before a court. I don't know many facilities or people who are very comfortable with self-appointing and saying, pull the plug. I think that it would require some court intervention and taking of evidence to determine what a person would have wanted. Now, there are other authority creating arrangements. For instance, you can be appointed the agent or the Social Security representative payee or the VA fiduciary, but understand that that's only having authority to administer the funds that are paid through that agency. An industry appointed agent, I call it pseudo authority, is the sponsor in a long-term care setting. Don't mistake sponsorship for legal authority. Hear me again. Do not mistake sponsorship for legal authority. I have had so many arguments over the years, and I can assure you that a sponsor is not a legal representative for a person. I've actually seen nursing homes that favor a sponsor over the agent named in a power of attorney, but with proper education, they understand that that's an incorrect thing to do. A sponsor is just the industry term for the person to contact in the event of an emergency, and very often sponsors play an important role because there is nobody who has actual legal authority. And then Medicaid also uses the term sponsor and will accept an application from a person who fills it out as the sponsor when the applicant can't make application him or herself. And of course, there are, under Alabama Medicaid agency, there are reps that can be appointed. You can find the forms on their website. Social Security, you can be a representative there. Almost every agency has that ability, but what you're doing is getting the authority to act for somebody in just one particular case. And we're going to talk about court-appointed agents a little further down. I do want you to know what a do not attempt resuscitation order is. It's a DNR, do not resuscitate or do not attempt resuscitation, and it can be signed by a doctor instructing that resuscitative measures not be provided to a person under a physician's care in the event the person is found with cardiopulmonary cessation. DNARs can be issued with the consent of the patient if they're competent, or pursuant to instructions in an advance directive if the patient is not competent or is no longer able to understand, appreciate, and direct his or her medical treatment and has no hope of regaining that ability, or with the consent of a healthcare proxy designated under the Natural Death Act, or at the instruction of an attorney in fact under a durable power of attorney that grants the agent the power to make end-of-life decisions in accordance with the Natural Death Act. Now, do not confuse DNRs with the end-of-life decision-making in a power of attorney. A DNR is in a very specific set of circumstances where there's cardiopulmonary cessation, and the person, you know, like you can break somebody's ribs. It can be very painful sometimes to people who get in a weakened state to be brought back through this kind of intervention. But this is where somebody's on the way out, you don't pull them back in, is essentially what's being communicated here. For many years, the DNAR orders were used from facility to facility, and when you left one place, you had to have another one created. Like you would leave the nursing home and you would go into the hospital, and there you would have to create another DNAR. But then in 2016, Alabama law created the portable DNAR, and for it to be valid portable DNAR, you have to use a form that is provided at the State Board of Health Administrative Code. Different facilities can still use their own forms, but they're not portable unless you use that State Board of Health Administrative form. It can be a lot easier than having to get the document created over and over again, leaving one facility and going to another. Now, when a person has failed to make any kind of directive and something absolutely has to be done, the family or the state through DHR has really no option but to go to court and get a guardianship and a conservatorship. The probate court can appoint a guardian to have authority over the body of an incapacitated person. And the definition of an incapacitated person is any person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, physical or mental infirmities accompanying advanced age, chronic use of drugs, chronic intoxication, or other cause except minority, to the extent of lacking sufficient understanding or capacity to make or communicate responsible decisions. You've got to meet that standard in a probate court to be named as someone's guardian. And the law provides a priority list of those the court should first appoint as the guardian, and they include a person named in a durable power of attorney. You see how important who you name in a power of attorney can be? Like if the family should disagree about what an attorney in fact under the power of attorney is doing, they may go to court and say, oh, this person shouldn't be in charge of this person's physical condition, where they live and all that. But the person that you named in the durable power of attorney is the first person in line to be named as the guardian. So that's an important designation. Next is the spouse or the spouse's nominee, the adult child, parent or parent's nominee, relative with whom the person has been living the prior 6 months, and a nominee of the caretaker of the person. Understand that the guardianship gives authority over the body, and conservatorships give authority over finances. Very often the court will appoint the same person to serve in both capacities, but every now and then you'll have one person as the guardian, a different person as conservator. But the thing is, whoever the court names, they have to get along, they have to agree. because the guardian can select where somebody lives, but the conservator has to agree to pay for it. So you can see where getting along and working together is very important in this, these different roles. To name a conservator to manage the estate of the person in need of protection, the following is the definition for the person in need of protection: unable to manage property and business affairs effectively for such reasons as mental illness, mental deficiency, physical illness or disability, physical or mental infirmities accompanying advanced age, chronic intoxication, confinement, detention by a foreign power, or disappearance, and whose property will be wasted or dissipated unless property management is provided, or for whom funds are needed for the health, support, education, or maintenance of the person, or those entitled to the person's support, and that protection is necessary or desirable to obtain or provide the funds. A lot of times you'll see in a conservatorship hearing where it's being alleged that daddy has taken up with a 25-year-old and is throwing all of his money away to her. And he is therefore not supporting his wife, or he's not supporting someone else like a disabled adult child. And as you can see, these kind of situations and these kind of cases can get kind of sticky, and they can be very disturbing. One of the reasons they're so disturbing is that these are not private affairs. These are their own court record. You're absolutely having somebody declared a person in need of protection, and that creates a record forever. The law provides for the priority listing of those who can become the conservator, and they include the conservator appointed in another jurisdiction, the person selected by the incapacitated person, because sometimes you see people join in. They say, I know I need help, and I trust that Bob will do a good job for me, so I would select Bob, and the court will listen to the incapacitated person. Next is the person designated by the incapacitated person's power of attorney, the spouse, the adult child, the parent, relative with whom the ward has lived for the last 6 months, the nominee of the person caring for the incapacitated person, and then the general guardian or sheriff. Some counties have a person who's designated to be the guardian, the general guardian for the county, and in places where that designation has not been accomplished, you then have the sheriff's office that stands in that role. Besides attorney's fees and filing fees, the court's required to appoint a different attorney to serve as the guardian ad litem to represent the person who is in need of guardian or a conservator or may be. That guardian ad litem can actually come out and say, I don't think this person needs a guardian or conservator. It's not often that you see that happen, but it can. You also have to, when getting a court-appointed guardian and conservator, you have to be bonded, and that's based on the value of the estate, and you have to account to the court at least every 3 years for all income and expenditures. Now, I have seen courts that have decided that that review needs to take place sooner. If something happens and they don't like how money's been spent or something of that nature, they can say, nah, until I change my mind, I want you back in here once every year or in 6 months or whatever, to remedy whatever the court feels like the guardian or conservator has not done correctly. But the point is that a court appointment to get authority is pretty expensive and time consuming, and it's ongoing. And that's why it's a real good idea, if at all possible, to go ahead and make plans while you can and sign the documents to avoid this kind of court intervention. We're going to have training. It's next week, a week from today, and it's going to be on documents and property arrangements to prepare for disability and death. And we're going to go into greater detail about individual documents and specifically for planning for death through wills and trusts and arrangements like beneficiary designations. So keep that in mind, put it on your calendar. Another thing that's very important for any caregiver to do is to not be blindsided by long-term care arrangements. This is the time to start looking at long-term care arrangements. A lot of people don't do this until it becomes a full-blown emergency, and you don't want that to happen. And the reason that I say that is because I've seen it happen too many times. Like maybe a family doesn't even know what services are available in their county. There are counties that don't have any adult daycare services. The cost of the different services can vary from county to county. I want you to look at the Genworth cost of care estimated for 2019 in Alabama. Shows that homemaker services are $3,394 a year. Homemaker health aid, $3,432. Adult daycare, $758. This is, I'm sorry, a month. Private one-bedroom assisted living, $3,250 a month. Semi-private room in a nursing home, $6,388. And private room in a nursing home, $6,783. If you stop and look at that and you know a thing or two about Social Security and how many people are on Social Security without additional funds for their retirement, there's an awful lot of people who cannot afford even a private one-bedroom assisted living, $3,250. Especially in a lot of the people that I see, that would be considered really good income. And a lot of people just don't have that much income. A lot of times families will go along and they'll say, oh, well, if we get to the point that we can't handle this anymore, we'll look at assisted living. But I'm not really sure that people even know how much assisted living costs. I think it's really important to get a handle on these issues and what's available, what will public benefits pay for, what will Medicare pay for, what will Medicaid pay for, what will long-term care insurance pay for, and what do you have to pay private pay? What will the VA pay for? All of these are very important issues to understand if you're a caregiver. Here are some resources that you might want to look at. This is a booklet on planning for long-term care in Alabama. It's an ebook. At our website, you can go there and you can download it or you can print it or read it online, but it goes into a lot of depth about long-term care planning. But it is a 2019 document, so it hasn't been updated in a year, but you will get the big picture about who pays for what in the long-term care arena. It is extremely important if you're a caregiver to understand Medicaid, because Medicaid's the primary single insurer for long-term care in Alabama. When you look at the cost of nursing home care, you realize that somebody's going to spend probably $84,000 a year or more, and there are not many people who can afford an extended stay in a nursing home at private pay rates, which is why I like to say it seems like almost all roads lead back to Medicaid. And in order to qualify for Medicaid, a person has to have limited income and resources, and Medicaid looks at your financial records for the previous 5 years. So don't go throwing away bank statements or anything of that nature, because you're going to end up going back to the bank and paying them to provide it again, whereas if you had saved it, it wouldn't cost anything. It's important to understand that all of the records come into play. I like to tell people that when you apply for Medicaid, you're going to feel like you've been through an IRS audit. And sometimes IRS is a little chummier than the Medicaid agency. It just depends on your worker and through what district office you're dealing with. But I'm saying it is something to get a handle on now to understand. I think looking back at the different actions people have taken for 5 years is what really throws people into confusion, because that's an awful lot of information to have to accumulate. And I say to people all the time, don't wait until you're right on the door of having to apply for Medicaid. Understand what you can and cannot do now to keep from having problems with Medicaid. I've provided a link to a resource. It's another ebook. It's about qualifying for Alabama Medicaid and long-term care at our website. And I do want to just briefly mention several Medicaid mistakes. A transfer penalty is assessed when a family member is paid for caregiver services without a caregiver contract meeting the Medicaid requirements being in place. And that's really important. If you need a caregiver agreement that meets their requirements, get in touch with my office and we can provide that to you. Gifts by the applicant or spouse during the 5 years prior to application are penalized. For every $6,400 given away, 1 month of penalty is assessed. Medicaid generally expects real estate to be sold for the tax assessor's appraised value. And whenever you sell it for less than that value, for every uncompensated value under what you should have gotten for the property is also considered a gift. So before you sell property, you need to get advice on alternative ways to value that property, but don't just run out and sell it for what you think you can get for it, because you can end up with a real problem with Medicaid. This seems real unfair, but repaying money to someone who paid for like your moving expenses or other things for you without a promissory note in place is considered a gift. Selling your property and investing it in improvements on the property of a relative is not a good idea, because Medicaid will say that you're enriching the property of the relative. Instead, the relative should use their own money to make the improvements and then enter into a rental agreement on that property. By the way, y'all, I could have probably done 10 slides on things to not do with Medicaid because it is a very difficult process applying for Medicaid. And there are an awful lot of things that you can do that are innocent enough on the face, but end up causing a problem. I think another thing you need to know about if you're a caregiver is the Medicaid estate recovery. Federal law requires states to recoup money spent for some Medicaid services, and it's important to get a handle on what those are. I've given you a link to a short ebook on Medicaid estate recovery in Alabama. A special needs trust is a trust that's created for a disabled person to supplement their means-tested benefits like SSI and Medicaid. And I have given you some examples of when a special needs trust might be created. Like a person who's on SSI and Medicaid inherits some money, grandparents who want to provide an equal gift to a grandchild, but one's disabled and they don't want them to lose their benefits. Or maybe a person needs to spend down a large amount of money or even a small amount of money before qualifying for Medicaid in the nursing home. If the money that's going into the trust belongs to the disabled person, they're creating a first party trust, and that's subject to a Medicaid payback. In other words, money in that trust left over after special needs are met over time, say the person dies, Medicaid gets paid back for the amount of money that they paid to keep the person's needs met in the facility. A third-party trust is one that the funds belong to someone else, like the grandparents who wanted to provide for a grandchild. There is no Medicaid payback on third-party trust funds. So it's important to recognize that whether or not you need a special needs trust is whether or not you've got a disabled person with special needs who does not want to lose those public benefits. This can be a wonderful tool to use. I'm representing a couple right now, and he is going to have to spend down $80-something thousand to qualify for Medicaid in the nursing home. And rather than having all that money go down the tubes, he can put it in a special needs trust and use it for his special needs. I have provided you a list here of what all the funds in a special needs trust can be used for. And we won't go through all of those, but you'll have it in the materials. We're going to have a training on October 7th about integrating long-term care into estate planning to look at ways to preserve as much money as possible while planning for long-term care. Now, there's one last issue that I wanted to bring up, and this is very troubling. We know to not leave people who can't handle stoves alone with a stove, and we know that when people are driving cars and they may hit other people or hurt themselves, there are all kind of liability issues. But I think a topic that's not being discussed enough today is guns. I have given you a link to an article about gun safety and dementia and people who have had experience in this area of how to protect people who are not, who are operating with diminished capacity but don't want to give up their guns. I particularly am sensitive to this issue because several years ago I dealt with a family, and the mother very calmly one morning got a chair, went over, stepped up on it, got up in the closet, got a gun down, walked over, put the gun to the back of her husband's head and shot him. And there was absolutely no indication that this was coming. She had dementia. She was severely impaired, and that gun was put up, I guess, you know, to protect everybody, like grandchildren coming in. But she knew where it was, and she went and she got it and she killed him. And I think that these are the kind of worst case scenarios that need to be looked at when you're planning as caregiver to protect someone. I lifted this diagram from the Alzheimer's Association, and it shows dementia and gun ownership in the US and how many homes have people with diminished capacity in it. And I think a lot of people just aren't thinking about the gun issue. So I want to get you to think along those lines for extra safety's sake. Now, again, I'm going to put the slides from this presentation on SlideShare. And then from there, I'll put it on our Facebook page. And I believe Panda will also put the slides there. Although you can look at the video again later, the way to get the actual written materials is going to be to access it through the slide shares that will be shared to Facebook pages. Now, do we have any other questions before we wrap up?
I don't see any, Jan. I did want to make a comment that Jennifer did add the Zoom link that you can RSVP for the next event that you had mentioned earlier. So if anybody's interested in that, for sure, go and click on that and try to go ahead and get RSVP'd and get signed up for that. So I don't see any on here. Jennifer, do you see any questions on Facebook at all?
No, I don't.
Great.
I guess
if y'all have any questions afterwards, you think of anything, feel free to get in touch with me.
I think that shows that you answered everybody's questions.
Okay.
It's a very, very, very informative presentation for sure. Well, Jan, I'm going to go ahead and share my screen then. Absolutely wonderful presentation, and you know, I don't think you could have painted any better of a situation than like the one you just went over, as far as, you know, dealing with individuals who with cognitive impairments around firearms, around vehicles, and I think Dr. Powers likes to include also power tools. So definitely something to try and think about proactively and get on the forefront of, because things can change rather quickly. So. All right, well, we won't keep you too long, but I did want to kind of mention briefly, especially for those that are new to Coffee Break, that are new to M4A and who we are and what we do. So I did want to kind of quickly go through who we are. We are the Middle Alabama Area Agency on Aging. Of course, that's what M4A stands for. We're located right here in the middle of Alabama. There are 13 other area agencies on aging that make up our network, and we cover all 67 counties. For us, we cover 5 counties, but we do cover Jefferson County for our senior employment program. But our agency's motto, to put it simply, is assisting all ages at all stages. So whatever scenario you can think of, we've probably got an answer, or at least a resource that we can reach out to for you. How it starts for us, we have what's called an Aging and Disability Resource Center, or ADRC. So you can contact us directly at our office, which we have at the end, the phone number for that. You can also come in person when we're open during normal hours, which right now we're actually closed because of the pandemic going on. But you can also contact 1-800-AGE line, and they'll connect you to your local area agency on aging if it doesn't happen to be M4A. Okay, and these are some of the key programs. I think Jan mentioned a few things earlier of some of the things that M4A does, but this is kind of a simple breakdown of some of our core programs that we offer statewide. Those range from nutrition to caregiver supportive services to senior employment to insurance counseling. In coffee break, and hopefully in a few weeks, we're going to have our shift counselor come on and kind of talk about open enrollment and Medicare. And so that's with that coming up at the end of the year, it's a good time for her to come on. So we do that in-house with insurance counseling. Of course, we partner with Jan to do legal assistance, elder abuse prevention, and other long-term care supportive services like the Medicaid waiver program that Jan talked so much about earlier, and kind of getting things in order to apply for programs like that for long-term care. If coming into our office is obviously not the best of options, or talking on the phone, if that's not a good option for you, we also offer online. So if you're doing this on behalf of someone else, or if you're doing this for yourself, you can go to www.m4a.org/referral, and you can fill out the information that we'll need to call back to do a follow-up on, to kind of get that process started for you. We have seen an increased number of calls with the pandemic going on, so please be mindful of that. But this is really the quickest way to get that information in, to get that full benefit screening through our ADRC, to get the information to the programs that are appropriate, and try to get you the help needed as quickly as possible, and really try to improve your quality of life. So that's really, again, that's probably the quickest way to get through. That goes through a queue, and it gets into the hands of our ADRC pretty quickly. If you need to keep up with any of the things that M4A is doing, or our partners, we do a good job of sharing different programs from around our region, but especially our own programs. We have, we're on most all of the larger social media networks: Facebook, Twitter, Instagram, YouTube, you see there. But we also have a newsletter that we send out weekly through email that we post a lot of our events in, a lot of our partners' events. We post a lot of legislative things that are going on, or local resources that we're aware of, changes like we recently shared one about Alabama Power with payment plans. So stuff like that, just kind of give you an example. Those are great for you to use personally, as well as to share with any of your colleagues or any clients that you may have. So feel free to join. If you visit www.m4a.org, it'll automatically prompt you to join that newsletter, and you'll have to sign up. If that way, that's probably the easiest way to go. But we put all of our events on Facebook, so make sure that you join us for that, or go ahead and click that you're interested in joining, so that you'll be reminded by Facebook. Here is our contact information personally for M4A. You can reach us at 209 Cloverdale Circle, Alabaster, Alabama, or you can mail us at P.O. Drawer 618, Saginaw, Alabama. There's our phone numbers with the toll-free version, and our email, our website. And I believe we have another question on Zoom, Jan. I want to make sure that we get you covered here. Okay. Actually, it's a question for us. So for us, we kind of focus on the areas that this is pertaining to the senior employment. Do you find employment in other counties is the question. Unfortunately for us, we focus on the 6 counties that we cover. However, the way that program works, to simply put it, is we partner with nonprofit agencies across our region to offer employment for individuals of a certain age. I believe, Jan, you may know the answer to this. I believe that age is at least 60 and older, but it may be 50 and older.
It could be 55.
It's somewhere in that range.
I'm not
and
really
I think you may be right. I think it is 55, but we partner with those agencies to provide basically part-time employment for individuals who are looking to get back in the workforce, and they kind of teach them skills and trades within that office to hopefully secure long-term employment, which is kind of the goal there, and we pay for that on their behalf. So if it's something more than what we're able to offer with that program, of course we would probably work with, of course, the temporary agencies or employment agencies within that region as a resource to hopefully get you connected back to. As far as the counties that we cover, we are in the central part of Alabama. We are in Alabaster, but we cover Chilton County, Blount County, St. Clair County, Shelby, Walker. With our senior employment program, we also include Jefferson County in that. So that's the 6 counties that we cover. Let's see. It looks like we've got another question here. We missed the first part of the presentation. You're not on Facebook. How else can you get a copy? One of the best things that you can do, if you'll email us, you can email Panda, P-A-N-D-A, at m4a.org. There, like our name there you see on the screen. Panda, like the bear, P-A-N-D-A, at m4a.org. We can send you a copy of the YouTube link once we get that. Also, Jan, do you want to mention again where they can find the slideshow?
Sure. They'll be posted, the slides will be posted on a place called SlideShare. And then from there, we share it onto our Facebook page, Jan Neal Law Facebook page, and the Panda Facebook page.
And if you don't have Facebook, like you said, we can also get it in our newsletter. So if you'll email us at panda@m4a.org, or if you're having any kind of trouble outside of that getting access to it, just give us a call, excuse me, at 205-670-5770. You can either ask for Jennifer Fuller or Jeremy Raines, and we will try our best to kind of find a way to get that to you the best that we can. But again, we will have this on our YouTube channel probably as early as or as late as Monday of next week. And of course, it's live right now on Facebook, so it's on there. So if you have anybody that does have a Facebook in your social circle, they can, of course, try to pull that up for you. But the quickest way will probably be emailing us, and we can give you a YouTube link to our YouTube channel to watch the cleaned up version of this presentation. So I hope that answers your question. Again, thank you, Jan, for joining us. We really appreciate you taking the time to really talk about a subject matter that nobody really likes to talk about, but we all need to know about. We hope that this has been informative, and we hope that this kind of gets the ball rolling for a lot of people to really proactively think about things going forward and go ahead and get life planned as best as we can. We know that it can be uncertain. I think 2020 is evident of that, but to try and be as prepared as we can be and to do the best that we can to get ready for what life throws at us. So thanks again, Jan. Everybody have a great rest of your week. Again, if you have any questions, feel free to reach out to panda@m4a.org or drop us a comment on our YouTube channel or on the Facebook video feed that we have here going live now. So have a great week.
Thank you.